Hi guys, Jonathon Daily, managing attorney for Daily Law, and I have a hearing on a motion to vacate default. So why not post a video of what is a default? First off, a default is typically when a party fails to respond, the defendant fails to respond as required by law. In this case, foreclosure case, plaintiff filed the foreclosure complaint. The defendant failed to file a valid response. So they didn't file an answer that admits or denies the allegations of the complaint. So now a judicial default has been entered against my client. So we're trying to vacate that. So what needs to happen here? Well, first off, we're going to argue that it was an improper default. If the default was entered improperly, then it should be vacated. Our argument for that is the defendant did file a motion for extension of time, and there was an alleged agreed order that was entered by the court. The order was required to be sent to my client, but it never was. So that's our argument. We don't need to show anything. It should just be vacated. However, if that argument does not fly, we have to show 3 requirements in order for a default to be vacated. The requirements are that there is an absence of gross negligence on behalf of the moving party. When a person is a lay person, that means they're not an attorney. It's a pretty low bar to me. Gross negligence has to be a very intense form of negligence. So that's one. A meritorious defense. So they're not going to just vacate a default. That would be pointless if there isn't some sort of meritorious defense you're going to allege. So if the person is like, I'm guilty, I'm liable, everything they're saying is true, of course you need to allege a meritorious defense. It does say that just denying the facts of the complaint may be sufficient. So it's not a big bar to meet. But again, you have to put it in the motion. And 3, due diligence in requesting relief by the defaulting party. So you can't wait 6 months. It really should be done within a month or 2. That is probably the toughest out of the 3 to meet, especially when you get hired a couple months after the default. But it really is going to depend on the judge. The law says if the judge is not sure about what to do, the safe bet is to go ahead and vacate the default so the case can be heard on its merits. So, hope this is helpful.